only request is if it can be granted for 6 months. So we will monthly we will pay partially and we will complete in 6 months, ma'am.
We take it then?
Yes.
It is expected that you will do it?
In 6 months, madam. We just require 6 months. Every month we will pay, madam.
There's an IA number is 8477.
8477.
8477.
कहाँ है इसका IA?
कल फाइल 8477. कॉपी भी करनी है.
एक बार कॉपी.
यहाँ पे.
Contempt Civil 296 of 2024. Learned counsel for the petitioner is present. इनका detail देंगे, designation.
Yes, sir. I'll give that.
Mr. So-and-so has joined the proceedings online. And Mr.
Yes, sir.
And Mr. Manoj Kumar, right? Manoj Lakra. Director, in that person, son of.
Yes.
Give the details. Right?
I will give that.
Is present in the court. It is submitted by the learned counsel for the opposite party, and also the associate authority who has joined online, that due to paucity of fund, they have not been able to comply the orders passed by this court in the petition, and as per the interlocutory application, at least 6 months time be granted for calculating the dues payable to the beneficiaries and to arrange the fund for it. The associate authority and the counsel for the opposite party has submitted that within 6 months time, the order will be complied in letter and spirit, and the payment will also be made within the time. It has been prayed that the matter be listed after a period of 6 months, and on the next date, they shall file a compliance.
Yes.
Post this case on 2nd of January.
So let me after a week, because at that time only the courts open, so we have an issue.
Second and one week would be how much? What date?
9th, cannot say how much.
9th.
9th.
Post this case on 9th of February.
January.
9th of January 2026. The compliance report should be filed latest by 5th of January.
Right. IA can be disposed.
Sorry?
IA can be disposed.
IA number 8477 2025, seeking extension of time is hereby disposed. That's all.
There is one more IA, that is
Thank you, madam. Thank you.
21 of 25.
Yes.
That was from exemption from personal
That was for
appeal.
the last date.
That was not disposed of.
We will not dispose of it.
Right.
Because if it is still not complied, they are bound to be here. If the order of this court is complied, then the opposite parties need not attend the court proceedings
Yes.
on the next date.
Thank you, madam. Thank you, madam.
From supplementary list for orders of defect item 1, CMP filing number 10662 of 2024.
Sorry?
One
It's a defective petition.
What else would defect?
This is restoration. Filing number CNP 10662 of 2024. The learned counsel for the petitioner prays for and is allowed time till 16th of July to remove the surviving defects preemptively. If the defects are removed within time, post this case on 18th July on draft.
Item 2, CMP filing number 13139 of 2024.
Pray for 2 weeks.
Same order. 16 तक का टाइम दिया है 16
Item for orders, item 3, CMP 775 of 2024.
One IA has been filed, my lord, for respondent 3 and 5. The former respondent, they have tried for substituting.
नोटिस करना पड़ेगा उनको when did they die when did they die
That is not in our knowledge. But as per the office report, it has come that is what has tried.
IA number 8289 of 2025 in CMP number 775 of 2024. Also for the petition has submitted that interlocutory application has been filed for substitution of deceased pro forma respondent number 3 and 5. That notice be issued to the proposed legal heirs and successors of pro forma respondent number
3 and 5.
3 and 5, whose details have been mentioned in paragraph 2 to the interlocutory application in the IA as well as in the main appeal. Through the concerned police station, the requisites for service, the requisites filed before this court within a period of 1 week. Requisites by 11 July. Post on first of August, awaiting service.
From table list for orders, item 2, first appeal 367 of 2018.
In this case, service report is still
Discuss service.
responding.
Discuss service. But data. Data. First appeal number 367 of 2018.
Last time paper for direction was for paper for.
फाइल करना पड़ेगा ना आपको सब्जेक्ट सर्विस. अभी तो कुछ पता ही सर्विस रिपोर्ट नहीं आया. This did it. ये क्या लेके आए? ऐसे नहीं होगा ना. अभी फ्रेश नोटिस के लिए हम कैसे ऑर्डर करें? बताइए, ऑफिस रोड पे रहना चाहिए ना, कौन कौन आदमी को सर्व नहीं हुआ है, ये तो हमको पहले से ही पता है। क्या बात है, नहीं समझ आता है। तो फिर अभी हम इनको ऑर्डर करेंगे फ्रेश नोटिस करने के लिए, तो कौन से रेस्पोंडेंट पर ऑर्डर करेंगे, बता दीजिए, आप ही बताइए कौन कौन से रेस्पोंडेंट पर हम ऑर्डर कर दें फ्रेश नोटिस करने के लिए। वहाँ से रिपोर्ट क्यों नहीं आ रहा सर्विस, बात हुई आपकी?
भेज दिए थे, वो लोग बोले तो कुछ बोला है नहीं, हम बोले कि इतना सर्विस रिपोर्ट है तो भेज दीजिए, उसके बाद तो कुछ होता ही नहीं। बोले थे मैंने ये जिसका जिसका नहीं हो उसका आए देंगे, अभी एक्सपायर हो गया उसका नहीं आए नहीं,
कहाँ कोई एक्सपायर हुआ?
बोले था कैंपस सर कुछ तो किया ही नहीं।
आप आज जो है इस लिस्ट को बिना कंप्लीट किए घर मत जाइएगा, हम बता दे रहे हैं कौन कौन से रिस्पोंडेंट एपियर नहीं हुए हैं या किसको फ्रेश नोटिस करने की ज़रूरत है। बस पूरा दिन एक ही काम है, बस अपील में है ना, हाँ बस यही काम करेंगे। दिस इज द ओनली थिंग यू आर सपोज्ड टू डू। अब बिना हमको कंप्लीट करके आप हमको रिपोर्ट करेंगे, उसके बाद भी ये ऑर्डर में इनकॉर्पोरेट करके विल सी व्हाट इज FA number 367 of 2018. The notice was issued to the respondents. White, order dated 5/9/2024, and by order dated 29/10/2024, time for filing the requisites was also extended by 3 months. The notices were issued fixing the date of appearance on 30/4/2025. By order dated 6/May/2025, office was directed to send express reminder to the concerned court for sending service report in connection with which the service report was not sent to this court. The matter was directed to be posted on 13/6/25. On 13/6/25, office was directed to enlist the remaining persons in connection with whom the service report is awaited. And the matter was directed to be posted on 20th June 2025. These two important. On 20th June 25, office was directed to send an express reminder to the concerned court for sending the service report, and the matter was directed to be posted today. The order was directed to be communicated to the court concerned through fax/email. And the office note shows that the express reminder was communicated to the court as directed. Today, when the case is taken up, as per the office note, in spite of express reminder, service report has not yet been received. With respect to the remaining respondents who have either not appeared or not filed a file count. No communication further has been received from the court concerned. This court is prima facie of the considered view that there has been gross negligence on the part of the concerned authority on part of the court concerned in not abiding by the orders of this court. In the matter of sending the service report of the concerned respondents, on account of which this court is not able to proceed with disposal of the entire batch of first appeals. Which arises out of land acquisition of the year. कब का है? कब का land acquisition?
1961.
Land acquisition of the year 1961. Are you sure? Land acquisition of the year 1971-72. कुछ भी मत बोला कर. 1971-72. The learned Registrar General of this court is directed to call for an explanation from the concerned court. Who would inform this court to seek an explanation from the concerned court. So that the reasons of non-compliance of orders of this court may be brought to the notice of this court. Further, this court is of the view that the date fixed in the notices which were issued for appearance of the concerned respondent has already passed. Therefore, आप फ्रेश नोटिस कर दीजिए। जो लोग बचेंगे उनको क्या करेंगे?
By the same rule.
खाली explanation कौन?
In the meantime, my lord, I will, in that direction, I will seek instruction. अगर ऐसा होता है, लेट से पहले I will be here with instruction.
इंस्ट्रक्शन का तो कोई जरूरत नहीं ना, कोर्ट का ऑर्डर हो तो कंप्लाई करना होता है। लेकिन ठीक है, इसको रख लें हम लोग। दो हफ्ता बाद बताइए कौन सा दिन। पोस्ट ऑन 18th of July। उनको बोलिएगा इसमें लिस्ट office is also directed to forward a list of the respondents whose service report is available. / who have not entered appearance by filing. इसको भी कम्युनिकेट करिए फैक्स से और इसको जो है जल्दी से आप टाइप करा के मुझे साइन करा लेंगे।
Item 401, second appeal table 2 of 2020.
The ladyship pursuant to the last order and pursuant to the IA filed by the respondents and IA number 8281 of 2025 has been filed by the appellants for substitution of the deceased respondent of file.
So, any objection? IA number 8281.
Yes, ladyship.
Notice was issued.
Yes.
Who are the legal names?
Your ladyship, paragraph 11 at page 7 of the IA. Page 7 of the
Have they entered appeal?
Your ladyship, respondent number 5 has not. Notices were issued.
Notices were issued to respondent number and it has been received, your lordship, but information I got for that I filed detail of death and legal heirs.
Notice कब हुआ?
The ladyship, firstly notices were issued on the matter was admitted and notices were issued on 20th January 2025. Thereafter on 25th.
This is with respect to respondent number 5, no?
Yes,
Yes, sir.
Notice has not been issued to the proposed legal years.
So technically it has not been. We have just
So
now
we
filed.
have to issue them.
Yes.
This, it will- There is a separate petition for delay also.
No, it no mention. The,
Here in the same petition you have read.
the delay in making the substitution.
And setting aside abatement.
There is a composite application. I think.
IA number 8281 of 2025. Learned counsel for the appellant has submitted that. Respondent number 5 has expired. And the interlocutory application has been filed for substitution of respondent number 5. The legal names of legal heirs and successors has been mentioned in paragraph 11 of the interlocutory application. Let notice be issued to the proposed legal heirs and successors of the deceased respondent number 5, for which he presents under ordinary process be filed by next Friday.
IA number 8038 members.
Sorry?
8038 IA number.
What
As
is
far
that?
the details of the
Just a minute. Holds this case on 8th of August, awaiting substitute. ID number
8038
8038 of
25.
2025, bringing on record the legal heirs and successors
Legal
of deceased respondent. Is hereby disposed of. Is hereby disposed of. Disposed of.
Yes.
You have given the name. Altogether 4 persons.
For admission item 402, contempt civil 211 of 2023.
Sorry?
Passport for few cases in on another court in
Lordship, in compliance of the para 10 of the order of your Lordship, you Lordship directed us to file one affidavit on 20th June 2025, your Lordship. In this regard, your Lordship, affidavit is ready, your Lordship. Order has been complied, but we could not file it, your Lordship. Para 4 to 6, your Lordship.
For few cases in Lordship, 2-3 cases in Lordship.
A principal amount has been paid.
Everything paid. Interest, your Lordship. Interest was left, that has also been paid.
On last opinion, Your Lordship, so far as interest is concerned, Your Lordship, pension which is due, Your Lordship.
If there is, if they have said that they have paid the interest, if you have any doubt or any dispute regarding computation, that you can raise the dispute. We will not go any further. Where have you stated that the interest has
4
been
to
paid?
6, your Lordship. 4 to 6. In earlier affidavit also we have paid everything, interest to Lordship, only left the pension was there, interest on pension. In this regard we were directed to file affidavit, and that is the affidavit in Lordship. Para 4 to 6 we have clearly mentioned in Lordship. The para 10 of the order has already been complied.
Interest amount has been processed.
Yes, Lordship. So far
उसके बाद payment
पेमेंट para 6 में ये दिया हुआ है, पेंशन का इनका थोड़ा सा दिक्कत हुआ था, उसमें लेट हुआ था थोड़ा सा, तो इसीलिए लोग बिल भी वो लोग प्रिपेयर कर लिए. Para
पेमेंट किया है कि नहीं पैसा?
Para 6 में they have mentioned that is ready, Lordship.
Ready means what?
Lordship, bill has been ready, we will pay you, Lordship. Last yesterday itself they have done the process, all process, 3rd July,
So
Lordship.
कैसे बोल रहे हैं order has been complied?
Because you Lordship, that is ready to.
It has not been credited to him. Are you satisfied by raising your bill, or you are satisfied by receiving payment?
Receiving payment.
Then this is no compliance.
Also, the Lordship will say to him that immediately we will pay. They will pay.
ठीक है, contempt case civil number 211 of 2023. Counsel for the petitioner seeks adjournment. Counsel for the opposite party has filed an affidavit stating that bill in connection with payment of interest has been prepared.
As far as the pension is concerned only, let other paid your must. Other interest will be paid.
She has filed an affidavit. She has filed a show cause on behalf of opposite party number 8 during the court proceedings which is taken on record. However, the admissible amount has not yet been credited in the account of the petitioner. Post on next Friday. To ensure full compliance.
Item 403, contempt civil 915 of 2023.
I have filed IA wait for 2 weeks time in this case. I have filed IA.
IA for what?
2 weeks time.
By
For reply and arrange the document. Last chance.
Supplementary supervision filed edition, wherein it has been stated that the order has been compliant. Order was for getting the land marketed and that has been done in the certification.
No, your lordship, उसी के लिए है. A specific direction given in the order, your lordship. The demarcation should be done in the presence of petitioner, your lordship. So petitioner was not present, your lordship. There is no any signature and demarcation जो हुआ भी है उसमें किसी चीज स्टोन पॉल्स वगैरह ये सब जो कराया जाता है बाउंड्री वाल में वो सब कुछ नहीं है. So just I have prayed for 2 weeks time, your lordship. I have.
IA number 8324 of 2025. Contempt case 915 of 2020. Counsel for the petition submits that this interrogatory application has been filed for grant of 2 weeks time to file reply to supplementary show cause filed by opposite party number 4 on 26th. Time to file the reply to the show cause is extended till 17th of July. IA dispose of, post on 18th.
Item 405, contempt civil 755 of 2024.
In this matter, the LP has been reserved for judgment.
LP has been filed.
Has been reserved for judgment. The
LP number
504 of 2024.
504
4 of 2024.
2024.
Reserved on 1st July 2025.
1st July
2025.
Contempt civil 755 of 2024. The learned counsel for the parties have only submitted that the appeal, the LP filed against the writ order is reserved for judgment, and the LPA number is LPA number for 504 of 2024. Posed this case on 29th of August 25 or after disposal of the aforesaid LPA, whichever is earlier.
Item 406, contempt civil 784 of 2024, along with item 407 and 408.
What is it?
I should point out at the very outset that similarly situated person not whose order was passed, similar order was passed, that is supervised. Now in that case, contempt matter, they have already implemented subject to the decision taken to be taken by the cabinet. And in our case, they are taking time and time. You know, so just see for a moment how a dozen of time has been granted at their instance.
You have selectively implemented.
that is not the case, my lord. My secretary is here, my lord. He will address. श्रीनिवासन जी, आप अपना माइक अनम्यूट करके एड्रेस कीजिए.
नमस्ते मैम.
हाँ नमस्कार.
Yes ma'am.
आपने कुछ जैसे पिटिशनर बोल रहे हैं, have you implemented the order in some of the with respect to some of the cases? In one contempt case, you have implemented the order subject to the result of some, I don't know.
Cabinet decision.
Some subject to the result of cabinet decision.
Ma'am, it is entirely different case, ma'am. In different court, in which it
Court
is
may
not
be
appropriate
different.
for me to make any
Just a
comment at
moment.
present, ma'am.
Just a moment.
But my request will be
Just
in
a
the present.
please hold on. Please hold on.
This is the order
Court
passed
may
by.
be different, but if the issue is the same, you cannot selectively implement it.
No, ma'am. The entire issue is different, ma'am. Different issue. It will be better, ma'am. My AG sir may argue properly, ma'am, because these are some legal aspects which I
AG is
cannot
not
explain.
here.
This
AG
is the
not
order
here.
passed by
Ma'am,
me. This is the order passed by me. On 3rd June, yesterday,
Where is the writ order?
read order that is
Where is the corresponding writ order?
quoted in the first paragraph.
Where is the writ order? You should have brought the writ order. This is the order of the year 2023, right? 19.5. This order was placed before the court. Our order was placed before the court because our order is 19.5.23 and this order is 12.7.23.
12/7.
Yes. Yes. See, there is an order of writ court in WPS number 4792 of 2018, wherein the order involved in the present case has been followed, and you have implemented so far as petitioner in that case is concerned. Yes.
Ma'am, my request would be, ma'am, that is entirely on different aspect the order was passed, ma'am. I will request the legal aspect of that maybe once again it has to be verified, ma'am. There are so many other issues.
Yes, please. You respond to this. You respond to
I have
this.
not examined that order.
You will examine it. You are not aware of your orders.
This
Neither your secretary is aware of the orders passed by this court. WPS number 4, copy दीजिए इनको निकाल के. Provide them a copy. दीजिए print कीजिए. हाँ तो ऐसा सिलेक्टिव कर सकते हैं क्या आप लोग?
नहीं, that cannot be done.
What kind of message will it go? कि जिस केस में पहले ऑर्डर हुआ है उसका यहाँ पे टाइम ले रहे हैं और सब्सिक्वेंटली जो ऑर्डर हुआ है उसका कंप्लाई कर रहे हैं.
That should not have happened. श्रीनिवासन जी, आप थोड़ा बताइए कि इसमें भी ऑर्डर ऐसा हो सकता है क्या, subject to approval of the cabinet. Perhaps that is the order.
So
he should take a call.
I do not know. He says you will represent. You say he will represent. Who has to represent? And if you are not capable of representing, you just leave. We'll talk to him only. Orders in the same matter as being passed by different benches. At least you should be aware of all the orders.
Your Lordship, this matter, the petitioner's case is pending for approval of the cabinet. It has already.
So why have you implemented the
Yes.
same order which has been followed in another court? You have implemented that order. And the order which is involved in this case, and this order dated 19/5/23, which is involved in this case, has been quoted also. इनको print दीजिए ना. You just have a look at it, and let us know what is the difference between the two. Selective होने की जरूरत नहीं है ना. It reflects a lot on you.
Yes, definitely.
दीजिए उनको दीजिए.
Yes, ma'am, I have seen. That has been similar.
This has been quoted in para number 4.
4 also.
Quoted, right?
Yes.
Now at para 5, that since the impugned resolution as contained in memo number 1845 dated 16/5/18 has already been quashed, no useful purpose will be served. Right?
Yes.
And then has already been disposed of.
Almost same.
Then
सेम महिला प्रसारण पदाधिकारी, लेडी एक्सटेंशन ऑफिसर. She was also the lady extension officer. Exactly same.
वो कहाँ लिखे हैं इसमें कि it will be subject to the result of the cabinet decision.
Notification हुआ.
कहाँ लिखे हैं?
Last में.
कहाँ लिखे? ये उक्त आदेश पर माननीय
मंत्री ग्रामीण विकास के अनुमोदन प्राप्त. अनुमोदन भी दिए हैं.
अनुमोदन भी दे दिए हैं. निम्न शर्त पर सब्जेक्ट टू कैबिनेट डिसीजन भी कहाँ लिखे हैं?
इसका भी अनुमोदन के लिए पड़ा.
मंत्री का अनुमोदन हो चुका है इसमें.
मंत्री का अनुमोदन हो चुका है और किसका अनुमोदन चाहिए?
यहाँ जो फ्री ले रहा है कैबिनेट.
डिपार्टमेंटल
लेडी एक्सटेंशन ऑफिसर ये भी थे, ये लोग भी थे. अब उनके लिए हो गया कि आपको मिलेगा और माननीय मंत्री का अनुमोदन भी प्राप्त.
Yes.
ये 3-6-25.
Let it be tomorrow वाला time we discuss with tomorrow Monday.
Mr. Srinivasan, your counsels are not apprising you. Let me apprise you, right? The order in this case, in the writ petition, was filed on 19/5/2022.
Yes.
Right? And then subsequently, another person had moved another writ petition in which the order was passed on 12/7/2023. And our judgment was quoted and it was followed. Right? Now the order which has been passed in the subsequent writ petition, that has been complied without the cabinet approval, but the honorable minister has given the approval as per the order produced before this court by the petitioner. So there cannot be any selective implementation. Isn't it? You cannot be selective.
My humble submission will be, ma'am. In last hearing, the madam has instructed in the order itself on 22/4/2025 that we have submitted to the cabinet, for which we did always the cabinet approval, ma'am. After taking that, but
Fair enough. Then why did you implement in connection with one person?
no, ma'am, that's why my request would be, ma'am. It may be kept on other day regarding this case whether it should be considered or because it is not proper for me to comment upon those orders immediately now itself because the last two paragraphs are contradicting nature and now I am not in a position to comment upon this, madam, because it is a different code. Maybe issue similarly, madam. So I am not competent to comment at present. Let us take if these three cases, in the case of contempt case number 784, 848 and 881, ma'am, in which actually from our side, three lawyers are representing the state of Jharkhand, Mr. Rahul Sabu, Ashok Kumar Yadav and Sachin Kumar. And the different court, the different lawyer is representing Mr. Mantu Kumar Yadav or something. So in a similar case, if four different lawyers are representing the state, definitely there may be slightly difference of opinion while making the submission, ma'am.
You see,
That is entirely
there can be difference of opinion in making the submission. But when identical orders are passed, right, when it comes to compliance from your end, then under such circumstances, as I consider it, that you cannot be selective. For one person you will implement the order, for another person you will say that it requires a cabinet approval. This kind of approach on the part of the state.
Yes, ma'am. Ma'am, in that case also, that's why I am not commenting upon that issue, ma'am. But is the circumstances warranted for that position is entirely different, ma'am. That is my request, ma'am.
I don't know. You have to explain. You have the onus is heavy on you to explain. Otherwise, it will reflect a lot on the state. You cannot implement. You see, if there are 10 litigants identically situated and similar orders have been passed in connection with all of them, you cannot selectively implement it, and for the rest you will implement it for a few, and then for the rest you will say it requires further decision. There is lot of finance involved in this. You cannot be selective. I can understand it requires a cabinet approval that will take its own time. There is no problem about it, but you cannot be selective.
Actually, ma'am, this is now pending before the cabinet. Already it was submitted in the last hearing also.
Yes, yes.
Our lawyer he had given the undertaking orally that it will be solved this one. It is in process, ma'am. We want to implement, madam. We are on that. But there are certain procedures, madam, that we are actually doing, madam. That case is slightly different, ma'am. It may be considered, ma'am. I will not go into the details
I
of
don't
those
know.
things.
Your counsel is not in a position to explain how is it different. So you respond to it. I will pass an order. So different counsel will not make the case different. Case will remain the same.
It made it, ma'am. That's why I am making the point. It made it. That's why we are.
I will just post it on next Friday, and I will just record this that this is the thing which has been produced before me, and then you respond to that.
There is a difference.
What
उसमें देखा जाए clause 4 जो order जो हुआ है department clause 4 देखा जाए दिनांक की क्या हुई
Clause 4 is what?
दिनांक 11/4/2025 को माननीय उच्च न्यायालय रांची द्वारा पारित आदेश के विरुद्ध माननीय सर्वोच्च न्यायालय सो एंड सो रूपा कुमारी सिन्हा दायर किया गया है, जिसमें 9/5/25 को पारित न्यायाधीश का कार्यकारी अंश निवृत्त है। मिस्टर कपिल सिब्बल अंडर सीनियर काउंसिल अपेल मिस्टर फेरली सबमिट दैट द ऑर्डर विल बी इम्प्लीमेंटेड विदिन a period of 1 month from today. The High Court may not proceed with the contempt proceeding till that time. With these observations, the special petition disposed of. रिट याचिका में पारित न्यायाधीश के आलोक में महिला सो माने जाने के संबंध में निर्णय लेने जाने हेतु मंत्रिपरिषद से क्षेत्राधिकार है। के संबंध में विभाग स्तर से गठित प्रस्ताव पर वित्त विभाग जाकर की सहमति प्राप्त है तथा संप्रति अग्रतर कार्रवाई प्रक्रियाधीन है। माननीय सर्वोच्च न्यायालय सो को पारित आदेश तथा रिट याचिका सो में पारित न्यायाधीश का असमय अनुपालन किया जाना है।
हमारे केस में तो आप SLP भी नहीं फाइल किया, इस केस में आपने LPA भी नहीं फाइल किया।
I am not defending. I am just saying.
You see,
why
you just see your conduct before the Honorable Supreme Court. You undertake that you will implement, right? And
नहीं यहाँ भी हम
अरे रूपा कुमारी इसी ऑर्डर को तो फॉलो किया है।
Yes, Your Lordship, we have even here also we have given undertaking that
is for 1 year. Last 1 year they are giving undertaking. Last 1 year.
Yes,
क्या चल रहा है?
undertaking that the order will be complied with subject to approval of the cabinet
You
decision.
see, when a judgment is passed, you sleep over the matter, right? This is a fact. This is a fact. Every day we are seeing that, right? You sleep over the matter. Your dozens of cases in LPA are dismissed on account of limitation. Is that correct or not correct? When the contempt is filed before this court, you go and rush and file an LPA.
Yes,
then you go to the Honorable Supreme Court. But within the time prescribed under the statute,
It is never filed.
It is never filed.
It is never filed.
Correct?
All appeals are time barred, that I say.
We do not say that
but
all.
we have now
Please hold on, Mr. Yadav.
Yes.
We do not say that all the orders passed by us are correct. We cannot say so. But what you do, you do not take the cases before appropriate courts, appropriate higher courts in time.
In time.
And therefore, why don't we see that there is some connivance? Yes, why not? You see, these are very serious matters. Your secretary is saying that it has financial implications and very serious financial implication. Why did you sit over the matter? You never filed an appeal against this.
2 years has passed, after the order.
Every day is important for the candidate.
Yes.
Then, and in one matter, when you go to the Supreme Court, you give an undertaking that you will comply. And here you will say no. Now the matter is pending before the cabinet, and till the cabinet takes a decision, you will not comply. And in connection with one of the candidates, you have already complied. What message are you giving to the society? What kind of message you are giving to the society? जिसका हो गया वो तो बम है ना, जिसको बोलते हैं आप लोग. हाँ तो फिर You should not have implemented. आप सुप्रीम कोर्ट में मॉडिफिकेशन फाइल करते हैं कि कैबिनेट डिसीजन होगा, कुछ भी करते जो यहाँ कर रहे हैं आप.
साल भर से कर.
Right?
Some time.
क्या टाइम हम आपको देंगे? What time should I give you?
My Lord Secretary is here. He will give an undertaking.
What undertaking he will give? Because he is not the person to take a cabinet decision. Whatever you do it in the same line as you have done before the Honorable Supreme Court. There is no difference between the two. What difference? Merely because in one case you have gone to the Supreme Court, that doesn't mean that there is any difference between the two. And if there is, Mr. Srinivas, I am telling you one thing. There is a very serious problem over here. The same matters are given to different councils. There is no coordination amongst the councils of the state. If there is one matter filed, there are if there is one person coming to the court against a one cause of action, there are identical cases to be filed in the High Court. At times, hundreds of cases are filed. And when different councils are allocated those files, you are likely to have different orders. And at times, when the case is dismissed by one coordinate bench, it is not even brought to the notice of the another court. So you do not coordinate it. You should issue instructions accordingly, arising out of same thing. The same council or same office of the state should handle those matters. And that is why you see there are so many conflicting orders. Thankfully, there is no conflicting order in this particular case, but we are seeing it every day. And the way your LPAs are filed, time barred. You see, once a state takes a decision to file an LPA, it means that there is some legal issue involved. And if that LPA is dismissed on account of limitation, it means what? We are very unhappy about it. A case should not be dismissed on account of limitation. Dozens of cases, as I am aware, dozens of cases of the state is being dismissed on account of limitation. Either you file it or you don't file it.
So many procedures.
Who are instrumental to all this?
The department itself.
We do not know.
They follow.
We do not know who is responsible. But somebody is responsible for the delay. You have to do. You can't be selective. We will not permit this. You have to explain as to why. What is the difference between Rupa Kumari's order and this order? You can't be selective. We will not permit this.
In the light of that order.
You give an undertaking that you will pass the same order.
Here,
I post it in the next week. You just he has to be there.
Yes.
We do not. You file an affidavit immediately.
Right.
As to why different treatment has to be given and how the case of Rupa Kumari Sinha is different from this case. With your Contempt Civil 784 of 2024. Counsel for the petitioner has brought to the notice of this court an order passed in WPS numbers 4792 of 2018, dated 12/7/2023, and has submitted that the order passed by this court in WPS number 6042 of 2015 and other analogous cases dated 19/5/2023 has been practically followed. He has also placed an order passed by the state dated 3/6/2025 to submit that the order passed in the case of Rupa Kumari Sinha in WPS number 4792 of 2018 has been complied, and it appears that the same has been complied pursuant to some undertaking given before the Honorable Supreme Court. But the order passed in the present case in WPS number 6042 of 2015 has not been complied, and the opposite party is praying time and again. He has submitted that the petitioners are suffering day-to-day loss on account of non-compliance of the order of this court, and the state cannot be selective in the matter of implementation of similar orders passed by this court, which has attained finality. Counsel for the state and Pura Naam unka denge with designation, Mr. Srinivasan, who has joined online.
K. Srinivasan.
K. Srinivasan, who has joined online, submits that he shall examine the matter and prays for some time so as to explain as to how the case of Rupa Kumari Sinha is different from the batch of cases involved in this case. If they are on identical footing, then there can be no reason to implement the order passed in WPS number 4792 of 2018 and not implement the order passed involved in the present case. Post on next slide. Try and find out the session.
Yes.
Try and find out. You see, either the representation was to be disposed of. You have all liberty, but please don't be selective. It does not look nice. If they are on identical footing, you give them the same kind of ruling. Or you can ask the cabinet to expedite the decision. Because once there is whatever it is, you come back on next Friday. I'm posting it on next Friday. If similar order can be passed subject to the cabinet decision ultimately, that can also be done. We do not know. How will you take it? But that order, इनको दे दीजिए भी order को copy.
एक copy दे दे.
The copy of the order passed by the department
Right.
has been forwarded to them.
Signed by him, signed by the same secretary.
Perhaps it's your signature, I don't know.
Yes, ma'am, I confirm that that is my decision only, but that is a selective. I will explain. Yes.
Next Friday.
Item 409, Contempt Civil 935 of 2024.
On the last date, your leadership had directed him to bring on record the breakup of the entire payment that has been made to the petitioner with regards to the retired dues, my lords. Now, the Deputy Commissioner Sahibganj, if the affidavit is not filed, the Deputy Commissioner Sahibganj had to be remain physically present, my lords.
Yes.
Affidavit has not been filed, my lords.
Yes.
It is filed also. Complete chart has been given in the affidavit also.
When did you file the affidavit? 26/6. Have you received it?
No, my lords.
Advocate clerk or the petitioner is not receiving it.
Actually, also कुछ डेट
Therefore, unable to.
लॉसिप ये हमें लिखे हम इनके एडवोकेट क्लर्क को फोन किए थे नहीं रिसीव किए देयरफॉर वो दिमाग लिख के हम फाइन किए
Ranjan Kumar.
लॉसिप हमें लिखे हम जी कांटेक्ट किया गया था हम कांटेक्ट
कहाँ है आप? दे दीजिए इनको अभी.
जब तुरंत दे देते तुरंत दे देते
Contempt Civil 635 of 2024. Counsel for the petitioners prays for time to seek instructions with respect to the chauffeurs dated 26/6/2025. 25/6/2025. Next Friday?
Next Friday.
Post on next Friday.
Item 410, Contempt Civil 949 of 2024.
Yes, please.
On the last occasion, we were instructed to file a supplementary to bring on record the required documents. That could not be filed on time because the petitioner was very elderly person. We are having it right now, if I not may permit.
What is it?
We have duly filed the representations also on 6/5/25 and 12/6/2025.
सब information आ गया आपके पास?
ये तो why not he was required to fill up the application and to submit before the university. Why not he
Prescribed form.
Prescribed.
Where is the
And he is
prescribed
filing-
form?
We have sent through speed post.
Where is the
That
prescribed
is
format?
required. That is required. He has only said.
Then for that, Lordship, only 1 week time can be granted to do the necessary.
First it will go to university, it will be screened by the university, and thereafter it will come to JPSC or
The last order was passed on 23/8.
No, on
17/6. But 28/6 is in
28/3 is in the prescribed format. You have not done the needful.
that only 2 weeks time.
Why 2 weeks time?
1 week. As
Why?
a,
No, we will drop that under.
he's a very elderly person, Lordship.
So elderly person should be more sound.
Only
So,
1 week.
Elderly person is an excuse.
No, humble. Only
No,
1 week.
all this is of no use. You have not submitted it in the prescribed form.
Only 1 week time can be granted. Only pay for that.
An affidavit dated 4/7/25 has been filed before this court during court proceedings, which is taken on record. Counsel for the petitioner has submitted that the representations filed by the petitioner has been brought on record. The learned counsel for the opposite party has submitted that the necessary information was to be furnished in prescribed form
before the university.
before the university. And this aspect of the matter has been recorded in order dated 28/2025. But the petitioner has not done the needful. Even the documents annexed with the supplementary affidavit does not reveal that the petitioner has complied the direction, has furnished the necessary information as required under law.
In prescribed format, you know.
In prescribed format.
Before
Counsel for the petitioner seeks adjournment. And submits that the needful will be done within a period of 2 weeks.
2 weeks.
Within a period of 2 weeks from today. Post on 25th.
Item 411, Contempt Civil 68 of 2025.
Those order has been complied and order has been passed, but it has not been complied in its true legislative spirit.
What is the letter and spirit of the order?
Let's say Lordship, if may allows me,
What is the nature of order?
let's say I'm referring the order. If your Lordship takes the show cause dated 19.
First, read the order.
Let's say they have annexed that order in the show cause order. So, if your Lordship allows me an order that opposite party is also there in the show cause. Page 53, if your Lordship wants to read page 53 of the show cause filed by opposite party.
No, we have to read our order first.
Yes, ma'am. Order is annexed.
It is here. Para 9.
Yes, yes.
page 53, para 9 minutes. Very minutes. Accordingly, these petitions are disposed of, enabling the petitioners of these cases who belong to the same family to jointly approach the phone number 2 by filing a detailed representation with supporting documents and a copy of the writ records and a copy of this order on 3rd of July 2023. In the representation, they may also disclose the persons whose right may be affected, that is all the legal heirs of dead Sultan Khatun, son of such and such, as mentioned in para 11 of the Contempt. Upon filing of the representation of the petitioner, phone number 2 shall do the needful and pass a reasoned order with regard to the entitlement of the petitioners or one or the other person which has been mentioned in para 11 of the Contempt. After granting an opportunity of hearing to all the concerned persons, in case of any dispute in connection with entitlement, it will be open to respond number 2 to take appropriate steps in terms of Land Acquisition Act 1894, so that the interstate dispute amongst the persons appearing before respond number 2 is ultimately taken to a logical end. The needful will be done by the respond number 2.
So what happened ultimately?
Ultimately, what they have done, the dispute has been, we have claimed the property on the basis of a registered sale deed. Now the notices were issued to all other legal heirs. They came and they disputed it. Now the opposite party says that since there is a dispute of title, you go before the civil court and get it declared. There is no dispute of title. I am having the registered sale deed with me. Moreover, if your lordship takes land,
is it in your name?
It is in the name of our father.
No, therefore your father is no longer there.
No, father is
so
not.
he must be having more legal years.
Mother is there and we are there.
Mother and you are there.
Yes.
And there are other persons also.
Other persons of
claiming.
Yes, they are claiming.
Yes.
So if your lordship,
they can claim. There is no
yes, they can claim. Award has been prepared. Only dispute is with regard to apportionment.
That's
so
right.
your lordship, opposite party number 2 may refer it under section 30 because under section 11 award has been prepared, but he has not referred it because he has said that there is a title dispute.
You have your remedies. We just know.
If
that order is not under challenge, whatever they have done, they have asked you to go and file a title suit. You challenge that order.
Your lordship's order is very clear, my lords. Your lordship has said that it has to be taken to a logical end. So it has to be taken to a logical end.
You see, as per their understanding, they say that you have to file a suit. You challenge that order.
My only submission to that effect is that as per
you go and tell him that you refer the matter under this provision.
He is not ready to hear, my lords. He is not ready.
Then you file a writ petition.
He is not, my lords. Your lordship's order has not been complied in true letter and spirit. Only section 30.
You see what steps they have to take, how they have to take. There are many things which has to be taken care of.
My lord,
they have asked you to.
Award has been prepared, my lord. It is not in dispute that the award has not been prepared. Award has been prepared. There is only a dispute with regard to apportionment. So, my lord, the reference can be made by the opposite party number 2 so that it can be ended, my lords, by providing the documents and evidences, my lords. Because they are only claiming that they are the legal heir. They don't have any document to say. We are having a registered
They
sale
may not
deed
be
now.
having any document. But once they claim, the claim has to be taken care of.
Plus, therefore,
Contempt
only,
Civil 68 of
to that
2025.
extent, I am submitting, my lords, your lordships.
Contempt Civil 68 of 2025. This petition has been filed, alleging non-compliance of order dated 12/6/2023, passed in WPC number 2385 of 2022, 2366 of 2022, 2371 of 2022, and 2479 of 2022. The learned counsel for the petitioner has submitted that pursuant to order passed in the writ petition being WPC number 2385 of 2022, dated and analogous cases dated 12/6/2023, the appropriate steps were taken, and when a dispute was raised in connection with entitlement/apportionment of the compensation amount under Land Acquisition Act 1894, the concerned authority, instead of referring the dispute under section 30 of Land Acquisition Act has asked the petitioner to get their title by way of get the dispute resolved through a competent court of civil jurisdiction. The learned counsel submits that the order passed by the Deputy Commissioner Chatra dated 13/6/2025 is not in accordance with law, and therefore the order passed by this court has not been complied with in every spirit. The learned counsel for the opposite party has submitted that the order has been complied, and if the petitioner has any grievance in connection with the order passed by the Deputy Commissioner, he has a remedy under law. It will go under section 30. Do that.
My lord, there are a number of issues here, Your Lord.
Must be, sir. I understand. Considering the aforesaid circumstances, this court is not inclined to proceed any further in this contempt proceedings. However, it will be open to the petitioner to take steps in connection with the order passed by the Deputy Commissioner in miscellaneous case number 24 of 2023-24 dated 13/6/2025. It has been annexed along with the show cause dated 19/6/2025. Proceedings from next. Already I have reviewed it.
Item 4 and 12, Civil Review 75 of 2025.
Civil Review number 75 of 2025. Nobody appears on behalf of the petitioner. The petition is. क्या है ये? क्या difficult?
Same, the order passed in that first appeal whereby the state and all those parties were debated.
Since petitioner is absent, post on 25th of July.
Item 4 and 13, Contempt Civil 75 of 2025.
Its order of the Honorable Court has been complied, but the grievance of the petitioner persists. I am praying that liberty may be given to the petitioner and it may be dismissed.
Contempt Civil 75 of 2025. Counsel for the parties are present. This petition has been filed for initiation of contempt proceedings alleging non-compliance of order dated 1/5/2024 passed in WPS number 3964 of 2023. The learned counsel for the petition has submitted that though the order passed by this court has been complied, but the grievance of the petition has not been redressed. Reason order has been passed?
Reason, there was direction for formulation of rules have already been framed, but that is not in consonance with the budget notification.
He submits that the rules have already been framed, but the same is not in consonance with the gazette. In view of the opposite submissions and considering the nature of order passed by this court is not inclined to proceed any further in this contempt proceedings. Accordingly, the contempt proceedings are hereby dropped. Gazette name or written?
Gazette notification was published in the year 2017, and the rule has to be framed in accordance with that gazette notification.
Rules से बनाया 2021 में.
Appointment rules have been framed as per the gazette notification of 2017. That has been mentioned in page 16.
Those rules have been notified.
Rules have
Notified. Yes.
Rules have been.
If the petitioner has any surviving grievance, petitioners have any surviving grievance, they may proceed as per law. The contempt proceedings are brought.
Item 4 and 14, Contempt Civil 78 of 2025.
Time litigation activities are being filed with the leadership, and that is not in compliance with the order. Leadership, we kindly see the last order dated 11th of June.
Yes, you are giving the breakup.
Minor issue. As per the contention of the department, they are saying that all dues have been paid, the only leftover is pension. And for
आपसे
pension,
क्या बोले थे? The supplementary show cause should include a table reflecting breakup in connection with the payments already made and admissible amount.
minor issue.
कहाँ है breakup?
ब्रेकअप इसमें एक पैराग्राफ में पैराग्राफ 5 में ये सीधे लिखे हैं कि all dues of petitioner have been paid. They have not given the breakup, but they
कौन है? इसको ऑर्डर समझ में नहीं आता.
district welfare
आपको?
officer.
आपको नहीं समझ
We have
आता है?
written a specific letter that.
तो फिर आप उनको डिफेंड क्यों कर रहे हैं कंटिन्यू?
Not defending, I'm
Then
just
you
saying
should
what.
say that the order has not been complied.
Only what is on the record, that's what I'm saying. बस जो वो लिखे हैं बस वो हम आपके सामने.
कहाँ है वो? Where is it?
ब्रेकअप नहीं दिए हैं, बस पैरा 5 में लिखे हैं.
समझ नहीं आता है उनको क्या? Yes?
A specific letter was given.
आपका वैल्यू नहीं है क्या डिपार्टमेंट में? They don't value you. एडवोकेट का वैल्यू नहीं होगा तो कोर्ट का क्या वैल्यू होगा? You are at the commanding position and they are at the commanding position so far as law is concerned.
The order of the court was
I
specific.
just do not know. I'm just asking you. You are at the commanding position or they are at the commanding position?
I am Milas.
वो जब आते हैं तो कुछ भी फाइल कर देते हैं. क्यों फाइल कर देते हैं? क्यों फाइल कर देते हैं? क्योंकि ये तो बनाते तो आप है ही नहीं. कोई भी बनाता है. Copy paste.
The SOF was listed.
So, don't you see whether the SOF is in accordance with the order of the court?
We did Milas.
Then?
We asked them to
Why did you file it?
the tabular form, but उनका यही कहना है कि चूंकि हमारा कोई बकाया है ही नहीं अलावे पेंशन के, तो we don't know what to put in the tabular. And one more
कहाँ
thing.
लिखे हैं? He does not know what to put in the tabular.
Milas, the explanation that they gave was the last counter affidavit may be seen.
इनके पास क्या ड्यूज है? पेंशन के अलावा कोई चीज का ड्यूज नहीं.
That's what they're saying.
कहाँ लिखे?
This statement is also contradictory to the
Yes.
annexure that has been annexed with the supplementary show cause, in which there is a specific stance that has been mentioned that pension इत्यादि का भुगतान करने के लिए अनुरोध किया गया है.
PPO जारी करने का पुनर्जीवित करने का अनुरोध किया गया. That is only with relation to PPO.
From where do we get that there is no other use except pension?
My last counter affidavit show cause में कहीं नहीं seen was page number 18.
18 से नहीं देखेंगे, affidavit से देखेंगे. That no table can be filed because there is no other dues except pension.
No, I concede Milas that the table has not been filed and the order has not been complied in essence as it was given on the last occasion. But the reason I'm just stating in front of my leadership.
Reason आपके annexure में नहीं देखेंगे, affidavit में देखेंगे.
ये last show cause का है.
Show cause का part होने से क्या होगा? You have to say
this-
it on affidavit
Only-
that no table can be prepared because there is no other dues except pension.
It has been given in the last show cause, that's why.
देखा para number?
Page
Para number.
in the para it has not been. In the recent order it is.
Para number 3.
Was,
Reason
I'll-
order में आप क्या क्या लिखते हैं अपने documents से that is no complaints. We do not know.
It was the order that was passed in the writ petition. In that we were directed to pass a reasoned order
In connection with what?
in connection with the retirement benefits and the dues that were.
Retirement benefits only means pension?
No, in that reasoned order, it has been mentioned what payments have been made and why the rest of the payment has not been made because Prapatra K was issued and some recovery was to be made.
Therefore, you were supposed to prepare a chart. इतना ड्यूज है, ये नहीं दिए, रिकवरी हो गया, ये चार्ट कहाँ से? ये कौन बनाएगा आपका चार्ट? चार्ट बनाइए.
हम reasoned order को काफी सारे details affidavit में लिखा था.
Yes, I do not know आपके reason order में क्या है.
हम उसको I'll file one more. I'll bring on the record on the affidavit what breakup has been given in the reasoned order.
The reason order that is being essentially last 2 days they have been specifically stating that some amount has been paid, some amount has been paid. Thereafter, the specific direction was that since that amount is of 2020 that has been paid, therefore, since we have given some breakup.
Contempt Civil 78 of 2025. The learned counsel for the petitioner submits that the order dated 11th of June 2025 has not been complied inasmuch as the opposite party number 2 in the supplementary show cause has not included a table reflecting the breakup in connection with the payments already made and admissible amount. Counsel for the opposite party has submitted that a show cause has been filed, but from the perusal of the show cause, no such table has been mentioned in any of the paragraphs of the show cause, nor there is any table to the in the annexures to the show cause. The district welfare officer, opposite party number 2, is directed to remain personally. Is directed to remain present before this court through online mode on next Friday to explain as to why the order passed by this court has not been complied and what is the impediment in complying the order of this court. So next Friday को online
If I may only indicate one, the statement that has been given is also contradictory to the document that has been released.
तो आने दीजिए मैं चार्ट अपनी करूँगी. The affidavit, it will be open to the opposite party number 2 to file an affidavit to explain his position. Online कराएं. जाते हैं से यहाँ बुला के पैसा बर्बाद करने का कोई जरूरत नहीं. यहाँ तो सब पिकनिक मनाने आ जाते हैं. Correct? Officers का पिकनिक मनाने का जगह नहीं है. बोलिएगा ऑनलाइन.
Item 4 and 15, CMP 322 of 2025.
Yes.
This is for restoration of the first appeal, which has been dismissed for non-compliance of the directive order due to technical reasons.
New petition for restoration. Okay, CMP number 322 of 2025. This petition has been filed for restoration of first appeal number 98 of 2017, which stood dismissed on 22/2/2025 on account of technical reasons, that is non-compliance of / non-removal of defects within 20 time, granted by the order dated 18/2/2025. आप कर देंगे
No, my lord, only thing is that case substitution decision is pending, my lord. Therefore, the names are not ready. So first of the substitution petition may be allowed.
The counsel for the petition has submitted that substitution is pending, and therefore the
Names are
defects could not be considering the opposite submissions. The order, the first appeal number 91 of 2017 is restored to its original file, and the CMP is allowed. Office is directed to place the first appeal before this court on next Thursday. यही का है ना 2017 कवर्ड केस है. कवर्ड केस है.
Item 4 and 16, Contempt Civil 396 of 2025.
Lordship, I am appearing in serial 417. LPA has been preferred and the notice has been issued to the respondents.
LP number?
Lordship,
LPA number
last
238 of 2025.
Lordship, last occasion is submitted, the LPA is prepared and listed on 12/6/2017. सब में एक ही
Contempt civil. तीनों में LPA की है.
जी एक ही ऑर्डर प्रतिक्रिया लॉर्डशिप काइंडली सी एक ही ऑर्डर से तीनों का है.
I am in 417.
एक ही ऑर्डर है.
417. 417.
416 also LPA.
Sorry?
416, serial number 416 LPA has been prepared.
Case number.
LPA 620
और third case में? नहीं
हाँ
और तीसरे केस में
यही मेन केस है। अरे उस दिन था पूरे यार टाइम लेके
Next date is given as 7th of August.
तीनों केस में एलपीए हुआ है।
तो
There are 3 cases, no?
Your Lordship, I am one of the case.
तीसरा केस में कौन? Sorry? They have not filed LPA. तो सप्लाई करिए और
Yes, Your Lordship.
in which case are you appealing?
Your Lordship, 948. 18.
948. You are appearing in 948. You want to comply the order? इसमें तो LPA का कहानी लिखा हुआ है।
उन्होंने कहा कि गणेश ठाकुर का जो मेन केस है उसमें एलपी है, उस समय ये एक ही ऑर्डर से तीनों का कनेक्शन। These three cases are disposed of.
उसमें 2 ही में LPA हुआ है। इसमें नहीं हुआ है। अनिल कुमार विश्वकर्मा में हुआ है, गणेश ठाकुर में हुआ है, संजय कुमार में नहीं हुआ है।
लेकिन ऑर्डर तो एक ही है, कोई भी एक होगा तो इफेक्ट हो सकता है।
ऑटोमेटिक सेटिस्फाइड हो जाएगा। ये कौन सा लॉ पढ़ेंगे?
तीनों कॉमन ऑर्डर।
कॉमन ऑर्डर होने से क्या हुआ? 3 जो फाइल हुआ था ना, तो तीनों का नहीं होगा तो फिर कैसे होगा?
My humble submission, order may be complied subject to the result of LPA lordship. LPA lordship, they have always taking a time. Order may be complied lordship subject to the decision of
आपको नोशनल प्रोमोशन मिला है जैसे कि अभी
रविशंकर सिमिलरली को मिला था।
ठीक है, नोशनल मिला है।
हाँ तो नोशनल के लिए
कंटेम्प्ट सिविल 396 of 2025, 948 of 2024, 947 of 2024. The learned counsel for the parties have submitted that in 2 of the cases, LPA has been filed. What will be? 948 है ये नंबर।
नहीं, ये जो तीसरा केस है कंटेंट 948 इसमें कनेक्टिंग इसमें
the connected LPAs are LP number 238 of 25 and LP number 620 of 2024. Post this case on कब रखते हैं बताइए, आप बताइए।
Next date is fixed in LPA is 7th August. Any date after 7th August.
7th August को डिसाइड हो जाने वाला है।
Your Lordship, in my LPA, the date is fixed for December, 10th of December.
Post this case on January का कोई डेट नहीं है।
Order may be complied lordship subject to the LPA के 7
awaiting the result of it.
अगस्त में कोई दे दिया जाएगा। अगस्त 7
Post this case एकदम एक सेकंड बताइए। 2nd of January 2026 or after disposal of the aforesaid LPA, whichever is earlier.
Item 419, Contempt Civil 4/6 of 2025.
Your Lordship, last order, Your Lordship have specifically directed to us to file the specific reply, but they have again justified their own order, Lordship.
But pursuant to the last order, the supplementary purpose has been filed.
they have acted as per the order of the LPL.
Yes.
And the clause 3 of the promotion may be deleted. Instead of that, they have given the face order and given notional promotion 6 and 7 lordship.
Yes.
Ma'am, Lord, the order passed in the division bench was that Lord, this should be given from the date on which they have been promoted, not from the date of joining.
Against the order passed by this court,
Ma'am.
you have preferred LPA.
No. Lord, this my Lord was pleased to pass the order in the light of the division bench order. Lord.
Yes.
And my Lord directed that the same benefit be given as has been given to the petitioners or the applicants in the case of, respondents in the case of LP number 57 of 2019.
That's right.
Lord, we have explained that Lord, the same benefit has been given. Lord,
Same benefit has been given.
Same benefit
You
has
have
been
given this financial benefit with retrospective effect from the date they were promoted to the post.
My
So what is the date of promotion?
My Lord, here the date of promotion, the notional date of promotion are two.
No. Date of promotion is date of promotion. We don't bother about notional date of promotion.
My Lord, pursuant to the order passed by the division bench, Lord, a decision was taken by the department, by the government. Lord. That decision is on record now, and let me place that decision. Annexure B, Lord. Annexure B, my Lord, kindly have, Lord. At page 41, page 20 to the supplementary so-called. Page 20. This is supplementary so-called dated 1st of July.
Annexure number?
Annexure number B, Lord, page 20.
Yes, this is in compliance of the order
This
of
is-
LPA.
Yes.
You see,
Madam.
whatever be the order of LPA,
Madam.
we are not bound by the manner you comply with. We are bound by the manner in which we pass the order.
Certainly. Certainly.
So,
I'll
therefore, in
demonstrate
the LPA, there was a clear direction to make payment from the date of promotion.
Yes.
Make that payment.
Not from the date of joining. Not from the there were before
date of
the
vacancy.
division bench, Lord, the issue was whether they are entitled to the payment from the date of vacancy or from the date of joining of the promotional post. But the honorable division bench directed no, you pay from the date of the vacancy. So here in this,
It is that.
Ma'am, the LPA division bench judgment, Lord, Madam, kindly have.
You see, the point is that if there was no vacancy, how notional promotion would be
Given the 5.
Certainly.
Then if there was no vacancy, you cannot give him notional promotion.
Yes.
But once you give him notional promotion, you have to give all the benefits.
Lord, here the prayer of the petitioner, Lord, pursuant to my Lord's order, Lord, a representation was filed. They said give us promotion from the due date or from the date of vacancy.
Court had especially directed, not have given initial dismissal.
Lord, let me make my submission. Lord, the prayer of the petitioner was twofold, Lord. That the juniors to them have been given promotion in the year 2006 and 7, Lord. They be given promotion from that date.
Why don't you challenge our orders?
No, we are complying.
No, you are not complying.
Lord,
We
I'm
are
saying-
not happy with your compliance. Please.
Lord, let me make submissions. Lord, they could not be given promotion, the financial benefit from 2006 and 7 because the vacancy was not there. It arose in 2012. And as per the division bench judgment, we gave the financial benefit from the
I
date of
just
vacancy.
want to know what is the notional date of promotion of the petition?
The notional date are two, Lord. There
How can be two notional
there are
dates?
two petitions.
Petitioner number 1.
Petition number 1, Lord. They are
1/11/2006
1/11/2006.
1/9/2007
and 1/9/2007.
1/9/2007.
Ma'am.
Right?
Yes.
So this is the date of notional promotion.
This is the date of national promotion.
And from which date we are giving them the financial benefit?
That has been given from 11th of May 2012, the day on which the vacancy arose.
I just do not know one thing. If there was no vacancy on 1/11/2006 and 1/9/2007, then under what circumstances have you given the notional promotion from these dates?
This is in addition to what has been given to the employee
I
connection.
just-
For the reason, Lord,
Please
because-
explain.
Lord,
If you are giving promotion from a notional date,
Ma'am.
then there has to be a vacancy on that date?
Lord,
Yes or no?
Lord, that may not be.
May not be.
May not be. For the reason,
Complaint is
not for the reason that here, Lord, rule under by relaxing the rule 58 of the Jharkhand, service code, Lord, the relaxation was given, Lord, and they have been given promotion. And for that period, Lord, it is not that they are not getting anything; they are getting the increments, Lord. Only salary they won't get, Lord. For the reason, Lord, the post was not vacant.
no. If the post was not vacant, then how have you given promotion from 1/11/2006 and 1/9/2007?
Lord,
Under what provision of law? Vacancy ही नहीं है. यहाँ पे 4 सीट है तो 4 ही आदमी बैठेंगे ना.
जी हाँ.
5वें आदमी को कैसे बैठा दिए?
इसलिए हम उनको सैलरी नहीं दे पा रहे हैं जो उस period में.
बैठाए कैसे?
हम नहीं बैठा रहे हैं, हम उसको नोशनल प्रमोशन दे रहे हैं. और
नोशनल प्रमोशन का क्या मतलब हुआ?
हम उनको सिर्फ
नोशनल प्रमोशन का क्या मतलब होता है?
एक
That you
particular
are giving benefit of promotion with a particular date, right?
मान.
If you give a promotion from a particular date, there has to be vacancy on that date. Or you will say no, it is not possible to give promotion from a particular date as there is no vacancy, and you will give the promotion from another date.
Lord, the juniors to the petitioner were given promotion in 2006 and 7. Lord.
If juniors to the petitioner was given promotion in 2006 and 7, so they will not suffer for your acts.
Certainly, Lord, and
So you give them
subsequently,
a benefit.
and subsequently, Lord,
भाई आप क्या किए? जूनियर को प्रमोशन दे दिए गलत.
जी हाँ.
गलत दिए ना? इनको नहीं दिए. तो इनको प्रमोशन करिए.
हम इनको कर रहे हैं.
क्या
हम
से?
इनको उस पीरियड का हम लोग
11/5/2012 से फाइनेंशियल बेनिफिट नहीं मिलेगा.
क्योंकि उस दिन से इनको ऐसा है कि जिस दिन इनको जिस डेट से हम इनको नौशो प्रमोशन दे रहे हैं.
आपको नहीं समझ आ रही है. कौन है आपके ऑफिसर?
सेक्रेटरी है, सेक्रेटरी एजुकेशन.
आपको नहीं समझ. You are not able to understand what we are saying. If you see the question of giving notional promotion has come up only because of your acts and omission, because you have acted in an illegal manner and junior has been promoted. And suppose you give them promotion now, then under such circumstances you are having a premium over your illegality.
Lord, in all, we have tried to.
एक तो इतना साल तक ह्यूमिलेट किया ना, ह्यूमिलेट. जूनियर का प्रमोशन दे दिया और इनको नहीं दिया. That amounts to humiliation or not?
That certainly amounts to.
That is why there is a concept of retrospective promotion also, particularly in a circumstances where a junior has been.
Lord, that aspect has been taken care of. Lord, we have taken into consideration the date from which the juniors have been promoted. That's why, Lord, that period has taken into consideration. We are paying the increment, Lord. Since they 2 persons current hold one post.
कर रहे हैं.
नहीं ऐसा नहीं कर रहे हैं, लेकिन हम कंप्लाई भी करेंगे हुजूर, तो उस पीरियड का उनको हम लोग सैलरी नहीं दे पाएंगे because that period was not vacant, मतलब that post was not vacant.
यहाँ का ऑर्डर क्यों नहीं चैलेंज करते? कि गलत ऑर्डर होते हैं.
नहीं गलत ऑर्डर नहीं हुआ.
क्या ऑर्डर?
गलत नहीं ऑर्डर. हम ये बोल रहे हैं कि जब कंप्लाई करेंगे तो हमको we have to comply in true letter and spirit. उस पीरियड का हम दे नहीं पाएंगे इसलिए क्योंकि उसमें तो एक पोस्ट ऑलरेडी कोई होल्ड कर रहा है. इसलिए जब हम जूनियर का कंसीडर कर रहे हैं कि इनको जूनियर के साथ में प्रमोशन होना चाहिए तो हम उस दिन से इनको इंक्रीमेंट दे रहे हैं.
Then you should have said, you should have questioned the order by saying that this order is incorrect because it is impossible to comply. He may have retrospective promotion, but financial benefit is to be given only from a particular date.
Because the honorable division bench also hold.
तो आगे जिनको जूनियर का आपने प्रमोशन किया ना, उनको डिमोट कर दीजिए from that date.
वो तो नहीं कर पाएंगे.
नहीं कर पाइएगा ना.
वो तो नहीं. Lord, division bench said that you give the benefit from the day on which the vacancy arose. Here also we are giving the benefit from the day.
Division bench doesn't say so.
सब में डिलीट किया क्लॉज 3 जिसमें वास्तविक बेसिस है.
My lord, may I please portion of the division bench order. इसमें है LPM.
Annexure 1 of the contempt.
Yes, it is.
Yes, I'm just placing it on this.
चार ऑर्डर लगाए सब में क्लॉज 3 को डिलीट किए जिसमें वो था कि वास्तविक तिथि से मिलेगा.
सबसे जो इंटरेस्टिंग चीज है ना
जी
कि आप लोग जो हैं आपको लॉ उनसे पढ़ना पड़ता है जिनको लॉ नहीं आता. आप अगर उनसे पढ़िएगा तो यही सब होगा.
But the benefit can be given only when the day from which the
you are
vacancy
here
arose.
to defend the state where they are right. You will not be able to defend the state where there are wrong. आप ऑफिसर से कैसे कन्विंस हो जाते हैं? विड्रॉल अधिवक्ता ऑफिसर से कन्विंस हो जाएंगे तब कैसे ही चलेगा?
बट वैकेंसी जिस दिन अराइज होगा उसी दिन से फाइनेंशियल बेनिफिट भी दे पाएंगे।
बोल तो रहे हैं, आपको ऑर्डर चैलेंज करना चाहिए। आप एक चीज समझिए, नहीं आप इसको बड़े इत्मीनान से समझिए। आपके जूनियर का प्रमोशन हुआ, ह्यूमिलिएटेड फॉर 6 years, आपको नहीं दिया प्रमोशन। उसके बाद जब आपको प्रमोशन दिया तो आपको बोल रहे हैं कि नहीं, जिस दिन से प्रमोशन दिए उसी दिन से फाइनेंशियल बेनिफिट देंगे, और जो पुराना चूंकि आप काम नहीं किए हैं इसलिए आपको नहीं देंगे। तो जो जूनियर को प्रमोशन दिए, राइट, उसका पैसा जिसने दिया है ना प्रमोशन, उससे रिकवरी करके इनको दे देंगे। फिक्स द रिस्पॉन्सिबिलिटी, किसकी गलती से जूनियर को प्रमोशन हुआ और किसकी गलती से। एक तो ह्यूमिलिएट भी किया, ऊपर से ये जो रेट्रोस्पेक्टिव और ये सारी चीजें तभी होती है ना, जूनियर को प्रमोशन के डेट से प्रमोशन क्यों होती है? It is only because of this. Because he has to be put at par, right? How will you put him at par?
Now we are facing a technical difficulty that he cannot be put at par.
आपके टेक्निकलिटी के चलते जो है ना, किसी को ह्यूमिलिएट नहीं किया जा सकता।
नहीं, इसीलिए हम लोग आज ह्यूमिलिएशन, इनका जो भी ह्यूमिलिएशन हुआ है उसको हम लोग कंपनसेट इतना ही कर सकते हैं।
कैसे करेंगे कंपनसेट, कुछ बताइए।
हम उस डेट से इनको नोशनल प्रमोशन दे रहे हैं और उसके बाद चूंकि उसका हम सैलरी नहीं दे पाएंगे उस पीरियड का, तो हम लोग इनको इंक्रीमेंट दे रहे हैं। इंक्रीमेंट है नहीं, हम बोल रहे हैं इसका एक पैराग्राफ इसलिए हम लोग लिखे हैं कि जब भी पे उसका होगा फिक्स, तो वो इंक्रीमेंट को जोड़ के ही होगा उस पीरियड का। और जिस दिन से इनको वैकेंसी अराइज हो रहा है उस पोस्ट को
इंक्रीमेंट तो वैसे भी उसके अधिकारी हैं। आप कोई मर्सी थोड़ी करते हैं,
नहीं कोई
और आउट ऑफ द वे थोड़ी जा रहे हैं।
हम जिस दिन से उनको देंगे नोशनल प्रमोशन उस दिन से हमको इंक्रीमेंट देना है, हम दे रहे हैं।
हम लोग को जो समझ आ रहा है हम लोग वही, कौन समझाएगा इसको, किसको बुलाएं बताइए। लेट मी अंडरस्टैंड, who will come and explain this? We do not say that all our orders are correct, but every order is to be complied till it is set aside. एक लाइन के अलावा दूसरा लाइन हम नहीं जानते। ऐसा हम नहीं बोल सकते कि मैंने सारे ऑर्डर्स करे, चैलेंज नहीं किए हैं तो कंप्लाई करिए।
हम तो कंप्लाई करते हैं,
कंप्लाई नहीं कर रहे ना, कंप्लाई करिए तो लेटर इंस्पेक्शन करिए। और जो मेरा ऑर्डर है हम ही समझेंगे ना क्या ऑर्डर किए।
we cannot, that is not our, we can only pray before my Lord, we can only make submission to Lord. I am making submission, Lord, that the benefit has been given, so as far as we could give, Lord, that has been given. Humiliation aspect, Lord,
कोई बात नहीं। आप जरा जो कंटेम्प्ट प्रोसीडिंग इनिशिएट करने का जो प्रोसीजर होता है, जो नोटिस हम लोग करते हैं, उसका थोड़ा प्रोसीजर के लिए थोड़ा असिस्ट करिए, अगला डेट पर करेंगे। कैसे ये सबमिशन नोट कर रहे हैं। कंटेम्प्ट केस सिविल नंबर 466 of 2025. The learned counsel for the petitioner has submitted that notional promotion has been given to the petitioner with respect petition number 1 and 2 with effect from 1/11/2006 and 1/9/2007 respectively, but financial benefit has been given only from 11/5/2012. The learned counsel for the opposite party is unable to satisfy this court as to why the financial benefit is not being given in terms of the order passed by this court in WPS number 1712 of 2023 dated 7/5/2024, when the matter was disposed of in terms of the judgment passed by this court by Honorable Division Bench in LPA number 57 of 2019 dated 14/7/2019. However, the counsel for the opposite party has submitted that while complying with the order passed in LPA number 57 of 2019, the financial benefit has been given from a posterior date and not from the date of notice of promotion. ये बोल रहे हैं ना?
Yes, sir. From the date when the vacancy arose.
And financial benefit has been given from the date when the vacancy arose. This court does not find any such stipulation in the judgment passed in appeal number 57 of 2019 that the financial benefit will be given from the date the vacancy arose. Rather, it clearly stipulates that financial benefit with retrospective effect is to be given from the date when the writ petitioners were promoted to the post. This court is, at this stage, this court is of the view that either the opposite party has not understood the letter and spirit of the order passed by this court and have thereby denied financial benefit from the notional date of promotion or they have no regards to the orders passed by this court. Who will explain? Who will give the shows now?
The opinion.
Appropriate order in this connection will be passed on the next date. आप आइए, वो फॉर्म और जो भी आता है सब आपको सुन के ही ऑर्डर करना। कौन है ओपी नंबर?
ज्वाइंट सेक्रेटरी डिपार्टमेंट का।
ओपी नंबर कौन होंगे?
एक ही है।
ओपी नंबर 3
डिलीट कर दिया।
Several details, sir.
3 deleted.
We will hear you and then pass. Next slide.
Item 420, Contempt Civil 704 of 2025.
Yes, what
Decision
happened?
order has been passed, so it may be disposed of with liberty.
Contempt Civil 744 of 2025. This petition has been filed alleging non-compliance of order dated 22/4/2024 passed in WPS number 4438 of 2022. The learned counsel for the petition has submitted that recent order has been passed in terms of the order, but the grievance of the petition has not been redressed. Liberty be reserved with the petitioner to challenge the reasoned order as permissible under law. Counsel for the opposite party has no objection to the fair hearing. Considering the appropriate facts and circumstances, this court is not inclined to proceed any further in this contempt proceedings. Accordingly, the contempt proceedings are hereby dropped. Liberty is reserved with the petitioner to take steps in connection with the reasoned order as may be permissible under law.
Item 421, Contempt Civil 784 of 2025.
Yes, petitioner? Yes. Show cause or compliance? Contempt Civil 784 of 2025. Counsel for the opposing party. Raised for and is granted time till 31st of July to either file show cause or compliance. Post on 1st of August.
Item 422, Contempt Civil 788 of 2025.
reason order passed in pursuance of the lordship's order is part of the contempt. Let's see now. Next year what?
Reason order in compliance of order dated. तो लगा दिया साथ में.
अभी लगा.
पढ़ी.
इसमें इन्होंने कहा कि इस ऑर्डर के कंप्लायंस में डायरेक्शन दिए कि ऑर्डर में भी कंप्लाय गारंटी द बेनिफिट ऑफ दिस रिटर्न फैमिली पेंशन विद 15 डेज डायरेक्शन के हमने सब भी लास्ट को सब पेज नंबर इतना देखिएगा लास्ट वाला लास्ट पैराग्राफ
ये बिना फाइलिंग को पास करना.
लास्ट पैराग्राफ में इन्होंने डायरेक्शन दिया है कि इन व्यू ऑफ द ऑर्डर फैमिली पेंशन में बी इशूड टू द petitioner. अपनी
We have held him entitled to family pension in terms of the lordship's order.
क्या हो गया? अब क्यों परेशान हो? तो हो ही गया?
ना वो नहीं गया, मिला नहीं पेंशन ना, इसके लेटर इशू कर दिए. लेटर स्पीड में अगर इसको फैमिली पेंशन का लेटर दिए, she is helping her lady, and only the paper transaction है.
हमने सिर्फ ऑर्डर पास करने के लिए बोला. पेमेंट रेमिट करने का ऑर्डर नहीं है. रीजन ऑर्डर पास कर दिया, पेमेंट कर दीजिए भाई. Contempt Civil 788 of 2025. Counsel for the parties are present. The counsel for the opposite party has submitted that the reason order passed by this court in WPS number 866 of 2023 has been annexed along with the contempt application itself. The learned counsel for the petition has submitted that although the reason order has been passed, but the payment has not been made. Considering the nature of order passed in this case, this court is not inclined to proceed in this contempt proceedings, as in the order passed by this court, no specific direction for payment has been made. At this, the counsel for the opposite party has undertaken to ensure that the pension in terms of the reasoned order, family pension in terms of the reasoned order dated 27/9/2024 will be remitted to the petitioner at the earliest. And at the earliest, कर दीजिए आपका responsibility.
Item 423, Contempt Civil 801 of 2025.
Same order कर दीजिए. 4 weeks हमने कितना दिया था? 31st जुलाई तक टाइम देंगे. 31st जुलाई तक टाइम दिए. शो कॉज और कंप्लायंस रिपोर्ट 1st of August.
Item 424, CRMP 1304 of 2025.
This is for modification of order dated 9/2024. Passed in inner division 168 of 2016. इस सेंटेंस को रिड्यूस किया गया था मतलब 6 मंथ रिगल इंगेजमेंट था और 1 लाख रुपया फाइन देने का था. एंड 2 मंथ के हमने डिपार्टमेंट 8 वीक्स का एक्सटेंशन मांगा था.
ये तो फाइल की 28/4 को 8 हफ्ता हो गया. जब टेकअप होगा तब से 8 हफ्ता थोड़ी होता है. जब से फाइल किए तब से 8 हफ्ता होता है. बताइए कब तक पेमेंट करनी है?
4 वीक्स.
CRMP number 1304 of 2025. Counsel for the petitioner is present. Nobody appears on behalf of the opposite party. This petition has been filed for extension of time to deposit the fine amount as was directed by order dated 18/9/2024 passed in criminal revision number 168 of 2016. Counsel for the petitioner has submitted that on account of किसलिए नहीं जमा किए? किसलिए नहीं जमा किए?
This is a daily wages labor.
The petitioner, on account of financial crunch, the petitioner could not deposit the fine amount. However, he has arranged the money and the period of deposit be extended till 25th of July.
6 weeks.
समझ में नहीं आया? 6 weeks खत्म हो गए.
8 weeks को मांगे थे मैंने 6 weeks कर लिया.
By 1st of August, considering the aforesaid submissions, the order dated 18/9/2024 passed in Community Revision number 168 of 2016 is hereby modified, and the time period for depositing the fine amount of ₹1 lakh is extended till 8th of August. Let this order be communicated.
Item 425, CRP 1381 of 2025.
Yes, what is it?
Your matter of distribution of criminal division 101010
What was the remaining defect?
One page has to be submitted.
Surrender certificate. CRMP number 1381 of 2025. Council for Execution seeks adjournment. Post on 1st of August. Next. समझ के आइए. Surrender certificate हम exact नहीं करते हैं. वो आपको देना ही पड़ेगा.
Item 426, CRP 1505 of 2025.
Yes, please. Come. Recording. Yes, please.
Lordship, the instant case has been dismissed due to the pre-entry order that was the criminal division 277 of 2023, and the instant CRP has been filed for restoration of the same. Lordship.
Criminal Revision number 277 of 2023. The learned counsel for the petitioner is present. Counsel for the petitioner submits that because petition has been filed for restoration of criminal revision number 277 of 2023, which stood dismissed on 13/7/2024 due to non-compliance of order dated 21/6/2024. The counsel for the petitioner has submitted that the defects could not be removed in time, and therefore the revision has been dismissed. He has submitted that on account of personal reasons, the defects could not be removed. Counsel for the opposite party has no serious objection so far as the prayer for restoration is concerned. After hearing the counsel for the parties, the time granted for removal of defect in criminal revision number 277 of 2023 by the order dated 21/6/2024 is extended till 8th of August. If the defect in the criminal revision is removed by 8th of August, office is directed to place the criminal revision before appropriate bench as per roster. The CRMP is accordingly disposed. Pre-entry आपका रह गया. आपका pre-entry ही रहेगा, तब नहीं कर दीजिए.
Obliged. I need not.
Item 427, CRMP 1533 of 2025.
Yes.
एक point और
Sorry?
स्टाफ रिपोर्टिंग में 10 रुपीज बचे हुए हम आइए फाइल किए तो थोड़ा टाइम पर नहीं
आइए क्या चीज़ के लिए फाइल की?
कंटिन्यूएशन ऑफ डिले इन फाइलिंग इन इन्वेस्टमेंट which was detected pointed out in the staff report 28/11/2024 and a stamp of British date was
I will just extend the period for
now
removal of
period for time period to be
ये आपका सेकंड टाइम चल रहा है, पहले भी हुआ था। हाँ? कौन सा रिवीजन कौन सा है ये?
रिवीजन नंबर 1141
तो पहले भी आपका डीएफडी हुआ था। कितना वो डीएफडी कराते हैं? इस बार तो कॉस्ट कराएंगे, बिना कॉस्ट के नहीं रेस्ट होता।
by mistake all defect
ये आपकी गलती है तो कॉस्ट दीजिए ना। यहाँ हम लोग खाली रेस्टोर करने के लिए थोड़ी बैठे हैं। डीएफडी कराते रहिए और रेस्टोर कराते रहिए नहीं। CRMP नंबर 1533 of 2025। This petition has been filed for restoration of criminal revision number 1441 of 2023, which stood dismissed for default due to non-compliance of order dated 22nd November 2024, passed in CRMP number 2680 of 2024, varying time for removal of defect in criminal revision number 1441 of 2023 was extended and the defect in the revision could not be removed even till the extended period, that is 30/12/2024. The learned counsel for the petitioner has submitted that only a small defect could not be removed due to inadvertence. Counsel for the opposite party has no strong objection to the prayer for restoration. Considering the opposing facts and circumstances, the time granted for removal of defect in criminal revision number 1441 of 2023, White, order dated 22nd November 2024 in CRMP number 2680 of 2024, read with order dated 22/6/2024 passed in criminal revision number 1441 of 2023 is extended till 1st of August. If the defects in criminal revision number 1441 of 23 is removed within the extended time, then office is directed to place the criminal revision report at the quick bench as registered.
For hearing item 428, WPS 55535 of 2015.
Yes.
The advocate, I've been instructed that the advocate has met with an accident.
Oh.
So,
ये वाकई बात है?
yeah, please.
मिस्टर नाम बताइए अपना नाम अभिजीत सिंह
Suman.
Counsel for the petitioner Mr. Abhijit Suman submits that Mr. Dibakar Upadhyay, advocate on the court, has been with an accident and therefore he seeks settlement. कितना चाहिए? कितना टाइम चाहिए? ऐसा तो नहीं कि बाहर खड़े हैं। जब भी मिलेंगे तो उनसे पूछेंगे जरूर। बताइए कब तक डेट दे दें? Respondent absent. You have not been instructed.
I've just been instructed to tell the court that he has met his limits.
क्या उनको एक्सीडेंट में हुआ कैसे पता चला?
Just a minor incident film from the bike.
Post or first of August.
Your Lordships, serial number 425, Your Lordship, this is a restoration case, and for the CRMP which has been filed challenging the family court order, Your Lordship, order passed ex parte and
Somebody had come. You are there.
my junior was there. I was on another
Just a moment. File please. आपके पास फाइल है? Why was it dismissed? Why
Your
was it
Lordship,
dismissed?
this was for removal of defects, Your Lordship. The
You
defects
are the
were-
husband or the wife?
I am the husband.
Why are you not maintenance?
Maintenance. The maintenance was
Criminal
awarded
revision
ex parte,
number?
Your Lordship.
Criminal revision number?
1010
23.
Yes, Your Lordship. The defects could not be served due to personal grounds of the council, Your Lordship. That defects could not be properly removed on time, Your Lordship.
CRMP number 1381 of 2025. This petition has been filed for restoration of criminal revision number 1010 of 2023, which stood dismissed for default on 12/7/2024 on account of non-compliance, on account of non-removal of defects within time granted by the order dated 22/6/2024. The learned counsel for the petitioner has submitted that on account of personal reasons, the defects could not be removed. Personal reasons of the counsel, the defects could not be removed. Considering the requisite submission, the time for removal of defect granted by the order dated 22/6/2024 in criminal revision number 1010 of 2023 is extended till
1 week is more than sufficient.
23rd of July. If the defects in the criminal revision is removed within the extended time, office is directed to place the criminal revision before appropriate bench as procedure. CRF.